on this morning's Ag Issues program. As always, a pleasure to bring on to the program this morning Roger McEowen, who is a professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, how are you this morning?
I'm fine, Greg. Thank you.
Well, I appreciate, as always, coming on to the program. Before we get started, wanted to ask you first, we just started with a brand new program this morning called the Agricultural Law and Tax Report, and you can hear that on 580 WIBW as well as the Kansas Agriculture Network. But Roger, I know, first off, congratulations on creating the program, but I know this has been a program in the making for quite some time.
Yeah, thank you, Greg. It's an idea I've had for a number of years, and I actually cut 4 demos in a Nashville studio about 2.5 years ago, and have been pitching the concepts to potential sponsors and radio stations across the country. And finally, everything came together earlier this spring, and then the issue was, well, I wanted music on the front end, on the back end of that. And I'll tell you, I don't have time to get into the details of it. There is quite a story behind getting the Mellencamp sound on the front and the back end of that. I will say this, however, that John is thrilled to be associated with it because of his longstanding passion for American agriculture. And that wouldn't have happened. I'll tell you this, Greg, that wouldn't have happened. I wouldn't have been able to get to the right people to get to him in Indiana if it weren't for Don Teskey. Don is the fellow that got me to someone that could get me to John's manager, that could get me to John, that could get me to Sony Music Publishing Company, and then last week we signed the license agreement on that. So that was a great, that really adds a lot to the show to get that sound from small town on the front and the back end of that. And so I'm thrilled that John is pleased to be associated with it all across the country.
Well, I'm looking forward to hearing that story sometime, but let's get right to it because we've got a lot to talk about, and this is something we didn't get a chance to talk about a couple of weeks ago. Fences, in this case, most people would think, okay, if they have a fence up, that's where the line is as far as the property line is concerned, but obviously that is not the case, and I'm sure numerous times you've been asked about that or have even written about that as well concerning whether fences are the boundaries or what the situation is.
Yeah, Greg, if you take tax and estate planning, all those related issues off the table, I would say that the next most prevalent topic of questions that I get deals with fences and then leases. It's right up there. It's all the time. There's probably not a week that goes by that I don't get a fence question or a lease question in addition to all the tax stuff. But you're right. Fences for rural properties, fences are generally considered by the landowners to be the boundaries. But by law, that the actual boundary is an imaginary line that's located according to the property description in the deeds to the properties. And often we get a discrepancy between the existing fence that's been there for decades. And I just dealt with one a couple of months ago where it was a fence that they could actually trace to it having been put up in the 1870s. And they were still dealing with remnants of that fence today, and they wanted to rebuild the fence. And we're wondering where the boundary was because that old fence was not necessarily on the boundary. And it had been described in the deeds way back in the 1800s by reference to piles of rocks and trees. Well, those piles of rocks and the trees were not really discernible anymore. And so the question was, where is the boundary and who owns what? And so the question comes up, well, how do we resolve this stuff when we have this issue come up for rural properties?
There's some basic principles, I guess you would call that, as far as, what some of the meanings are and what some of the, I guess, basic principles are as far as, okay, which side is which, and what's the demarcation line?
Yeah, there are. That existing fence is typically considered to be evidence of where that imaginary line between the two properties is located, and it really doesn't matter much whether the fence is permanent or not. But it's also possible, and in many instances, it's likely that an old fence has been used as part of the description of the land as the property has changed hands. And so it's not unusual for a farm property to be sold according to existing fence lines. And those descriptions might be, particularly if you're in the eastern third of the United States, or basically east of the Mississippi River, that you end up with what's known as a meets and bounds description in the deed that'll describe that fence that way. And those are bizarre. They're really tough to deal with. And I tell my law students, be thankful that you're in Kansas and you're west of the Mississippi, because when you're reading deeds, it's a lot easier to work off the government survey system than it is a meets and bounds description, where you're describing a tract of land by a series of directions that trace the perimeter of the land. And it may refer to an old fence in that directional as is describing the boundaries, or it may refer to a post or a railroad spike or a water course or a tree. And it's just really messy. But we also will see in some rural areas, I've seen deeds refer to the boundary of a farm by general location. Such as a farm on such and such a road, so many miles from town, or I even had a number of years ago, Greg, during my first stint at K-State, I had a fellow call me and he said, "I know you're coming out to Garden City to speak. Can you come and see me on the way out?" And he said, "When you take that road that angles off toward Garden City, when you turn." Basically there at Larned, you know what I'm talking about, and you go past Jetmore. And he said, you get past Jetmore, and there you go about a number of miles, and he said, you'll come to a tree. Turn south at the tree and go 7 miles, and you'll come to my ranch lane and go another 3 miles up the lane. Well, sure enough, I'm driving along, and you go about 20 or 30 miles, there's a tree. Well, that must be the road. Well, we get descriptions like that indeed. And then, of course, the survey is another basic principle that's out there in terms of how we describe property by survey. But that brings us back to, well, what do we do with this existing fence line that's there, this old fence that's been there a long time?
Yeah, and you talk about passage of time, going back to, like you mentioned, hundreds of years ago. As well. What about something like adverse possession? How do people treat that, or what type of situation does that put this situation in?
Yeah, well, the mere passage of time will not it will not cause the fence to be substituted for the property description boundary. So the fact that the fence has been there for decades doesn't matter much by itself. However, patterns of usage of the land on each side of that fence may cause the fence to become fixed as the boundary and have the legal effect of changing the boundary that's set out in the deed. And that's where you get into adverse possession. So if I've treated a fence line that I know is not on the actual boundary as the boundary, and it's given me more property than I'm legally entitled to, but the other party who also knows that existing fence line is not really the boundary, and they know that I'm encroaching on their property, and they don't do anything to boot me out of there, for a period of time defined by state law, and in Kansas that's 15 years, then I can actually end up filing a quiet title action and have the title to that discrepancy, that land that's in between, titled in my name. But a lot of these adverse possession type claims will fail in court because both parties have thought that the fence actually represented the boundary. So there's no intent to claim any additional property, which is the requirement for adverse possession. So you have to be careful with respect to that. So it's basically one, if you know where the boundary is and you know somebody's encroaching on you and you don't do anything about it, you can end up losing that strip of land if you don't act on it within, in Kansas, 15 years. Now, in other states, that's as little as 2 years. Iowa's 10. Nebraska is shorter than 15. I think it's 7, if I remember right. So it varies from state to state. So you just have to be careful with respect to that.
Roger, I'm sure I probably can't even ask how many times you've run into this as landowners have seen these, say, okay, we know we've got a boundary somewhere here, but I'm sure there are several types of ways that takes place that where they say, okay, this is what the boundary is, whether it's agreements, memos of understanding, or what? Probably just what they think the location is of that boundary itself.
Mm-hmm. Yeah, and there are various ways that you can come to a resolution of that with your neighbor. Of course, the least preferred method was probably one of the most popular methods 2 to 3 centuries ago, and that is dueling, pacing, taking 10 paces and then shooting each other. We still get, people get upset about fences. These are, you can get some really testy type situations, and thankfully most of them do not result in shooting each other. But one way to do it is enter into a written agreement with your neighbor. Just settle that uncertainty about the boundary on the basis of a written agreement, and then have corrective deeds issued, and the property descriptions of the adjoining tracts will be changed to reflect the fence line according to your written agreement. Now, frankly, that doesn't happen very often, but that is one way to do it, and say, all right, here's what we're going to do, and we'll just have deeds corrected, and off we go. You can also enter into a memo of understanding to settle a boundary dispute that designates the old fence line as the boundary. And you can have that recorded in the land records, where it's going to bind not only the present owners of the adjacent tracts, but all their successors too. But to be enforceable, the boundary in that instance has to be uncertain or in dispute. So the memo is technically, we call that a parole agreement. It's not subject to state law governing conveyances. But even so, I think it's a good practice for that memo to accurately describe the affected land and the parties that sign it. And then the parties need to observe the property line, of course, that's described in the memo. Another way to do it is by the doctrine of practical location. That's how we would establish that old fence line as the boundary. And so that situation arises where one party occupies up to the fence line for the statutory time frame, the same time frame as we talked about concerning adverse possession. That's 15 years, knowing that the fence is not the true boundary, but not knowing where the true boundary is located. Now, with adverse possession, we know where the true boundary is, and we're adversely possessing that person's property. Here, we know we've got a fence that's not on the boundary, but we really don't know where the boundary is. Then, if we've got that situation, then neither the memorandum, that parole agreement that I talked about just a moment ago, nor boundary by acquiescence applies. So it's kind of doctrine of practical location. We'll just treat this as the boundary. If the real boundary goes through thick brush and trees and water, we don't want to mess with a fence that's there. So we just, practically this is the best place for it. So we agree that that's going to be the line. Or in some states, we can have an equitable exchange, is what the courts call it. One party is ordered by the court to trade property on one side of the line for property on the other. But that's a really extraordinary remedy, and courts don't normally grant that, only if the parties can show that the true location of the boundary will present an unusual hardship or some other circumstance. In other words, we've got a pasture in Kansas that nobody has maintained for 50 or 60 years, and it's got all kinds of vines and brush, and we don't want to cut through that, put a fence through that. So we'll just trade property and figure out a nice place to put the fence. So, it shows flexibility in the law to deal with these issues. We don't have to get upset at our neighbors, but it's always good when you buy a farm to figure out where the boundary is the fence on the boundary, what can we do to correct it if it needs to be corrected, or are we comfortable with where it's at? We'll just continue to build and maintain that fence in its existing location.
You talked about that maybe it's a situation where, you don't want to get into dispute with your neighbors, but of the cases you've seen, isn't that probably the case, though, that the neighbors that have boundary disputes, they're kind of unhappy with each other in that aspect of not being able to settle the situation?
Oh yeah, they're almost always upset, and that's why they're calling me. I've told people over the years, no, I don't deal with domestic matters. I don't do family law. I don't do divorces. I don't want to get involved in that. But yet I get into fence stuff, which is probably just as bad in many instances. In fact, I was trying to find somebody, trying to find an attorney for somebody just last week, and I asked 3 attorneys that, nope, I'm not getting involved in fence disputes. They're always messy. I don't want anything to do with them. Well, yeah, that's kind of the nature of it, Greg. We're dealing with land, and we're dealing with ownership and possession of that land, and that's a touchy subject. And so when you buy property, it's important to understand where those lines are, and it's really important. I've done a couple of pieces on this over the last 6 to 8 months, hopefully helping realtors as well as surveyors understand these rules, because I tell you, there's still a lot of misunderstanding out there. I've talked about this stuff for 30 years, and it still is amazing to me the inconsistency in terms of application of the law and understanding of the law amongst parties such as surveyors, realtors, as well as general public and even attorneys. Fence law can be a bit confusing, particularly when you have people from an urban area that move out to a rural area. And we don't treat the boundaries and the fences the same as it is treated in town, where everything's clean and neat and everything's platted. We know where the lines are at. And usually the problems there are pretty simple. You just have a neighbor that's not respecting where the line is. But in agriculture, we often, we don't know where the line is, or we just treated a particular line as the boundary, and it turns out, that's not the surveyed line. Well, in agriculture, more often than not, the actual treatment of what we think the boundary is will govern more often than a survey will.
Bottom line in all this, and you just mentioned it a little bit ago, know the rules.
Oh, absolutely. Know the rules. The county extension offices have fence law publications. If you're buying a rural property, go grab that publication. That's a good publication. I have lots of things that I've posted about fence law too, but there's a lot of information out there. Ask that county agent about it, and they'll get information in your hands that you need to hopefully avoid dueling with a neighbor over fence issues.
All right, sounds good. And Roger, I know we had some more to talk about, but there was a lot to talk about there. So as always, appreciate you joining us on the program, providing insight on this, and I'm sure somewhere down the line we'll probably that topic will probably come up again.
Yeah, and I probably just stirred up interest from some people today, and my email and phone will be burned up with fence questions today, but that's the way it goes.
All right, that is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program this morning here on 580 WIBW.